Hi guys, and welcome back to Contract B. This week we are up to topic 9, and topic 9 is the first in a 2-topic series on remedies. Now, if you have a look at our mind map here, you will see that the readings for this particular bundle of topics on remedies are fairly comprehensive. So what I'd like to do is suggest a way for you to chunk up your readings, to split up your readings so that they're not too burdensome over the next couple of weeks. So for week 9, I'm proposing that you get all of your readings for damages in the casebook and the text done this week, and try and make a start on the readings for restitution. Then next week, week 10, finish off your readings for restitution and also equity. There's not a whole lot in those two little mini topics, okay? And that will leave you enough time to then go back to the chapter in the Wilmot text and casebook that dealt with misrepresentation, because you'll remember that all of the readings for misleading and deceptive conduct under Section 18 are grouped in with that chapter on misrepresentation. So that's the way I suggest that you break up these two topics, and then your readings won't be too inordinate over the next couple of weeks. So here we go, and let's look at damages. Okay, so the way we're going to lay out this particular video is we're going to look at 6 main parts of the issue of damages. Firstly, a quick look at the nuts and bolts, nothing really much there. The big 3 are causation, remoteness, and mitigation. And I'm hearing, torts. What's happening here? I thought this was contract law.
Mr. Krabs, I am so confused.
Yes, it is. There is some crossover here with certain notions in the law of damages so far as contract is concerned with torts. However, there are some fairly important differences which you need to bear in mind. Okay, then we'll look at the heads of damage, and finally the issue, the perennially vexed issue of liquidated damages. So in terms of the nuts and bolts, actually now I'm really regretting that choice of pink. It's rather harsh on the eye, isn't it? The main objective, obviously, for contractual damages is to compensate the plaintiff for the loss that they've suffered. So contractual damages are compensatory. They are not punitive. So you're not meant to be hitting the breaching party, the defendant, with a big fat stick and penalising them in such an extraordinary way that they'll never do naughty things again. It's just simply to get the plaintiff out of the bother that they've incurred in relation to the contractual breach. So the first big question, obviously, is there a cause of action? And you've had a look at various different causes of action this term. So, for example, you've had misrepresentation, both negligent and fraudulent, give rise to a right to claim damages. You also looked at various different issues to do with defective performance, which will give rise to a right to claim damages. So that's the first logical cab off the rank, if you will. You've got to have a cause of action that sounds in damages. Secondly, you've got to have causation. Thirdly, not too remote. And finally, the plaintiff has to mitigate their loss. Now, the first two there for causation and remoteness, same kind of thing as torts. Plaintiff has the onus there. And in terms of mitigation, the defendant has to show that the plaintiff failed to mitigate their loss. So looking at the first substantive issue, which is causation, I don't really need to labour this stuff for you too much, hopefully, because torts really should have equipped you with a really solid background knowledge in most of this. So what I'll kind of do is more of a cook's tour this week, rather than labouring various different points. We can kind of skip over them rather lightly, thankfully, because a lot of this stuff should be ringing bells for you. So causation, we have the main test in contract law being the but-for test, and it doesn't have to be the sole cause, it just has to be a cause. In all of this stuff with damages, calculation of damages and the whole area of damages is really more of an art than a science. even you have the High Court in Commonwealth and AMAN saying, well, it's acknowledged that there's a fair amount of guesswork in this kind of stuff. So the courts are going to take a common sense kind of approach in this kind of matter. And particularly where there's two or more causes of a plaintiff's loss, they're going to have a good look at things and decide, well, okay, which party really should bear legal liability here? And that's exactly what they did in the Alexander case. In that case, the plaintiffs had obviously suffered some economic loss. One of the causes was some mistakes that had been made by some auditors. The other was a change in government fiscal policy at the time, and the court had to take a look at each of those causes and decide which really was the one that was legally significant. And in that case, it was the government change in fiscal policy that was the real cause of the plaintiff's loss in the court's view. And so that's where the causation lied. So really, it's a question of legal liability rather than fact here. In terms of contributory negligence, again, another term familiar obviously from torts. However, in contract law, we really don't need to worry about it too much. The only time when it's terribly significant is where you are running a concurrent action in contract and tort. And in that kind of a situation, you're going to fall under the apportionment legislation, which is on foot in all the states and territories. And that will allow the court to reduce your damages if you yourself have contributed to your loss in some way. And obviously your damages amount is going to be reduced by the amount that you have contributed to your own loss. The only time where contributory negligence really does cut in at common law is the kind of situation where the conduct is serious enough to basically constitute a break in the chain of causation. So here we had, in the Lexmead case, a faulty towing hitch that was bought from a supplier. It was faulty, however, and as you guessed it, the towing hitch actually did break whilst it was in operation. Very, very nasty situation here, because when it did break, the trailer careered across the traffic and actually killed a father and son in another vehicle. Obviously, the victims' families sought redress, and the farmer then sought to sue the manufacturer. And the question was, well, who had really caused this quantum of loss? And it was held, I think, quite sensibly by the court in that case, that it was the farmer's conduct in using that towing hitch that then led directly to the loss that was suffered. Why was that? Because the farmer had actually used this towing hitch for some months whilst he knew that it was defective. So apparently the defect was obvious on inspection. So he knew he was using something that was not safe, and therefore that conduct was really the conduct that caused his own loss. And the court just let that loss where it lied. So that's the issue of contributory negligence insofar as contract law is concerned. It leads very nicely into a discussion of the novus actus, again, something you will have discussed in torts. But if there is a secondary event that intervenes to break the chain of causation, then that event will be deemed to be the cause of the loss, and anything else that happened prior will not be the cause of the loss. Now, that supervening event has to supersede the original breach in potency, so it has to kind of wipe it out such that it's no longer considered to be the real legally significant cause of the loss. So the next major area that you need to consider is remoteness. And again, this should be ringing bells from torts. Nevertheless, there are some significant differences in terms of contract law. The main case is Hadley and Baxendale. And here we had the owner of a mill suing a carrier who had carried a rather large crankshaft from the mill to some engineers to be repaired and then delivered it back. Now, delivery back took 5 days longer than was absolutely necessary, and the mill owner tried to sue the carrier for the 5 days worth of profit. The question was, well, was this kind of loss going to be recoverable, or was it too remote? Now, the court laid down 2 different limbs of remoteness, and under the first limb, your loss will be recoverable from the other party, from the defendant, if it flows naturally from the usual course of things. And the problem here was that the carrier was just a carrier. They just picked up this part and put it on the truck and carried it to the engineers and carried it back. They didn't know that without this part, the entire mill would be shut down. And even if they knew the part was important, there were other things that could have eventuated that they didn't know about. I mean, the mill might have had a spare crankshaft there for all they knew. So because the mill being shut down completely was not the kind of loss that was, usually within the contemplation of the parties as something that would happen if there was a delay in delivery back, then recovery was denied. So that's your first limb. The other case that the text goes into is Kufos and Chazannikov, rather boring sugar case. I won't bother you with it now. You can explore that at your leisure. In relation to the second limb, we have the main case being the Victoria laundry case. I really like this case because it brings out the 2 different limbs of the Hadley test quite nicely. They had a little bit of loss under the first limb, which they got up on, and a little bit of loss under the second limb, which they fell down on. It's quite a nice enunciation of what the second limb was all about. And in that case, you had a laundry operator that would dye garments from one colour to another. Obviously, it needed to do this in big boilers. It engaged a boilermaker to move a boiler, and the boiler was damaged in moving it. And so obviously the laundry operator sued because they lost a whole heap of dyeing contracts while this boiler was being fixed. I think it was out of operation, yes, it was, for about 5 months. So a substantial number of dyeing contracts were lost there. Now, fairly obvious that if you're going to be contracted to move a boiler for a dyeing operator,
Now, brown gal. The arsonist has oddly shaped feet. The Human Torch was denied a bank loan.
A laundry operator, then the kind of loss that you're going to, foresee as a not unlikely consequence of breach would be the loss of the dyeing contracts. So understandably, the laundry operator got damages for loss under that first limb. However, the laundry operator had also concluded a number of lucrative dyeing contracts that paid a premium for the service. Now, the question there was, this was a special kind of loss. It was kind of out of the ordinary. Was it too remote? And the court held, yes, it was too remote, because those kinds of special circumstances wouldn't have been in the contemplation of the parties as a natural, foreseeable, not unlikely, probable consequence of breach. And unless the defendant actually had knowledge of those lucrative dyeing contracts, or the plaintiff had told them about the lucrative dyeing contracts, then that's not the kind of loss that the boilermaker was responsible for. So that's the second limb in Hadley and Baxendale. I'll just quickly recap on those tests. The first limb is that the loss has to be fairly and reasonably contemplated by both parties because it arose naturally according to the usual course of things as a probable result of the breach. And you see courts saying things like it was not unlikely, or in the majority of cases, this is the kind of loss that would have occurred. So this is a stricter test than just reasonable foreseeability, okay? It has to be probable. So greater than 50% of the cases, this would be the kind of loss that would eventuate. That's your first limb. Note that difference with torts. It's not reasonable foreseeability, it's probability. It's not unlikeliness. It's in the majority of cases, okay? The second limb revolves, as we saw in that Victoria Laundry case, around the issue of special circumstances. Did that defendant know about those special circumstances at the time it concluded its contract with the plaintiff? So the plaintiff has to show either, as I said down the very bottom there, the defendant has gotten that special knowledge from the plaintiff, or the plaintiff has to know that the defendant already had that knowledge at the time of contracting. If that is the case, then you will be able to claim, unlike Victoria Laundry, for the losses flowing from those special circumstances. So that is the issue of remoteness. But that's not all we have to say on the issue of remoteness. There has been a debate in the courts about whether you need to foresee just the type of loss, the general kind of loss that could be suffered, or do you have to not only foresee the kind of loss that's actually suffered, but also the extent or the magnitude of that loss. And that was decided more favourably for the plaintiff in the Parsons and Utley Ingham case. And there they held that you really only needed to contemplate the type of loss, the general kind of loss, not the extent. Okay, fine point, but one that's needed to clarify certain cases. And in that case, the farmer bought a hopper to store pig food. The hopper was faulty, and the pig food, the nuts for the little piggies, got contaminated, and unfortunately the piggies died. Obviously the farmer sued to recover for the loss. And the question there was, well, is this the kind of loss that could have been within the parties' reasonable contemplation? Would the death of quite a number of pigs be something that was, not unlikely? And the answer was yes. Here in this case, the hopper was unfit to store the pig nuts. It's a natural consequence of that the food might become contaminated, and a natural consequence of that is that the pigs might become sick or injured. It wasn't necessary for it to be foreseeable that the whole heap of pigs would die, but it certainly was foreseeable that if they ate contaminated food, they'd be injured or became ill. And so regardless of the fact that there was a more serious extent of loss, that didn't really matter, because the extent was just a flow-on effect of the result of the pigs becoming ill. So in terms of contemplation, what do you need to contemplate? Just the type of loss, not the extent. And now we come to the issue of mitigation. Mitigation, really, it's just another one of those common sense things that, has become enshrined in the law over time. So obviously, if you're a plaintiff and you've suffered loss because of something that the defendant has done, you can't just sit back, fold your arms, put your feet up and watch TV for a while all the time the loss is just growing and growing out of control. You can't actually claim for loss or damage that you could have prevented. And just common sense. It is what we call a negative duty upon the plaintiff in a contract, that if the other party breaches, that they will do reasonable steps, they will undertake reasonable steps to stem the flow of losses. Okay, onus is on the defendant to show that the plaintiff has failed to mitigate. If the defendant doesn't actually bring up the issue of mitigation, then it will be presumed by the court that the plaintiff has acted reasonably and has mitigated any losses as required. The plaintiff only has to take reasonable steps to mitigate. You don't actually have to do everything that's within your power to stem the flow of losses, okay? Just reasonable stuff that's within your power to do, you should be going ahead and doing it. You don't have to do everything that's required. Now, some examples. First thing to note, the area of commercial contracts. Generally speaking, if a defendant breaches and offers then subsequently a substitute contract to try and make up for the breach or keep the relationship going, Yeah, usually in a commercial situation, it's going to be a reasonable offer, and probably as a plaintiff, you're going to have to accept the offer and continue on with the substitute contract and just sue for damages for anything that's less favourable than the original contract. The situation's different in employment contracts, and we'll look at that in just a second. In Paisley and Saunders, we had 400 pieces of silk delivered monthly. The price was to be paid in one lump sum in a month's time of contracting. The plaintiff failed to pay on time. Now, when that happened, the defendant thought that the plaintiff was insolvent. Okay, there were circumstances that indicated this to the defendant. So, not unreasonably, if I was a supplier, I would say, yeah, okay, I'll keep the contract going, and I'll still give you the silk that you've contracted for, but I want payment in cash. Okay, I don't want any more of this defaulting business going on. The plaintiff refused this offer and said, no, I want the same kind of terms and conditions. And eventually they had to buy on market. Now, when they bought on market, unfortunately for them, the price of silk had gone up, and so they had to pay more than what they originally had to. They sued the defendant for the difference in damages, and it was held, no, you actually had the option. You had a perfectly good substitute contract offered to you. You could have had the same T's and C's except for the payment issue, and you should have taken that and proceeded on. The damages that you've now sustained are a result of you refusing that reasonable offer of a fresh contract and going ahead and being a bit pig-headed, going to the market and paying more. So they got nominal damages only. So moral of the story there, if you're a plaintiff, if the defendant's breached, they offer a reasonable kind of arrangement, new fresh contract to keep the thing going, keep the relationship going, slightly different T's and C's. You're probably going to have to accept that. If there's anything less favourable, you're going to have to squabble about that down the track. But if you try and buy on market and it costs you more, then those costs are your own. In terms of employment contracts, the court in Paisley says, look, often these are a different class of beastie than the ordinary commercial kind of contract, because it's not necessarily the case where you have these interpersonal relationships that the fresh contract that's offered as a substitute after a breach to kind of keep the relationship going, it's not necessarily going to be reasonable. And they said there are some things that might get hidden in those kinds of contracts that might make them less beneficial really to accept as a measure of reasonable mitigation of your loss. They can include terms like, demotion. I'll keep you on as an employee, but at a lower rank or level. The contract might require you to abandon legal rights that you have against your employer. Or at the end of the day, really might be a very bad deal that the employer has really only offered as to say that they've actually provided the plaintiff with an option, so that they have this argument to make against the plaintiff that they failed to mitigate their losses and therefore reduce their own damages. So there's less imperative on plaintiffs to accept a substitute contract by way of mitigating your loss where the relationship is an employment relationship. The question in all circumstances here, whenever a defendant brings up mitigation, is, was it reasonable for the plaintiff to accept this contract in substitute for the original one as a means of mitigating their loss? If not, and it would be perfectly reasonable for the plaintiff to refuse that contract, then it's not going to be any advantage to the defendant to bring that up, because the plaintiff has done what's reasonable. So that's the issue of mitigation. And this is as good a place as any to leave it here for this video. You can go and have a stretch of your legs, have a cup of tea, and I'll see you shortly for part 2 of damages.